Please be seated. Ready for argument in 22-787 in the interest of J.Y.O.
May it please the court, Ms. O'Neill will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court, counsel. My name is Michelle O'Neill, and today I represent Hakan Aksuzler, who is here in the court with me. From the human side of this case, Mr. Aksuzler is fighting for the stability of his home life and the stability of the home that his son Jackson has lived in for the entirety of his life. Obviously, we're here to talk about a property division, but divorces don't happen in vacuums, and children live in homes. And it is important to Mr. Aksuzler that the point be made that the home is a stable place for his son and in which his son lives. This case has been pending since 2017 and unfortunately continues in litigation in the trial court even to this very day. There are 4 issues before the court, the legal side of the case. First involves the standard of review and whether there is a question in the body of family law as to what the proper standard of review in family law cases in general is, and in property division specifically. The second is what is the characterization of a house in light of a mistake in a refinance deed, and what is the proper remedy. The third is what is the characterization of a post-divorce discretionary bonus, and hoping that I have time to get there, what is the alternate method of calculating a mixed interest, an undisputed mixed interest, in a retirement account where evidence such as older bank statements are not available. First, addressing briefly the standard of review. The courts of appeals, starting with the Lindsay case that was first authored by the very respected Justice Ann McClure in the El Paso Court of Appeals in 1998, have undisputably, I think all of the courts of appeals have unanimously used a 2-prong standard of abuse of discretion to judge family law cases where the 2-prong standard is generally stated as, number 1, did the trial court have sufficient information upon which to exercise its discretion? And number 2, did the trial court err in its application of such discretion? And the courts of appeals widely believe that the first prong of that subsumes both a factual sufficiency and a legal sufficiency review. This court's decision in 2018 in the Bradshaw matter, which was admittedly a plurality decision and admittedly a decision that was very fact-intensive and limited to the scope of the facts therein, seems to have stated a different standard. It would have been a perfect opportunity for this court to have very easily stated the 2-prong standard. Certainly, Justice Devine's concurrence stated the 2-prong standard. I believe even Justice Boyd's dissent stated the 2-prong standard, but the plurality opinion stated a different standard. And I recall the day that I read this opinion, the day that it came out, I called several of our appellate cohorts and pondered whether this opinion stated a different standard for appellate review in family law cases. The Bradshaw case states that division of property should be corrected on appeal only where an abuse of discretion is shown in that the disposition made of some property is manifestly unfair and unjust. And it goes on to state that a determination of whether the property division decreed in a divorce constitutes an abuse of discretion presents a legal rather than factual question for appellate review. And in deciding that legal question, a trial court is entitled to no deference. It goes on in the next paragraph to state that In the circumstances presented, can it be just and right as a matter of law in dividing the community estate in a divorce?
Could it be that these differences can be harmonized by the other axiom that's often quoted, which is, yes, the decision is reviewed for an abuse of discretion, but a trial court has no discretion to incorrectly apply the law. So if there's a legal principle at play and the trial judge applies that legal principle incorrectly, there is, de facto an abuse of discretion. No matter what the state of the evidence is, there is some piece of evidence or some fact that as a matter of law, because of the legal principle, governs and controls, and the trial judge just didn't properly apply the legal principle.
I agree with that as a general statement of the law. I think the facts of that case, which don't necessarily need a full rebearing today because of the nature of those facts, but that case did not really have that exact situation. That case, because it was a division of property, was a question of whether an 80-20 division was sufficient, and I believe this court held that an 80-20 division was not a just and right division, but deserved a more severe division of property.
But turning to this case, and for example, the bonus, if the trial judge or the Court of Appeals incorrectly determined that the bonus was not sort of earned during the marriage, but just a contingency, if that's an incorrect legal determination, you'd agree that it's not really being reviewed based on the evidence, it's based on the correctness of that legal principle.
Well, I definitely agree that when a trial court incorrectly applies the law, that a Court of Appeals or this court has the right to reverse the case based on the law, not based on the facts. I think the question I was raising first as to the standard of review is whether we even have factual sufficiency review left after the statements in the Bradshaw case as a general proposition. And maybe that's a question that doesn't need too much time spent on it given the shortness of time today, other than the question that many of my cohorts that are appellate, family law appellate specialists are asking because of the confusion that this court has never adopted the two-pronged standard and has not really stated whether there is a factual sufficiency review beyond what is stated in the plurality decision in the Bradshaw case, which is definitely conflicting with what was stated in the concurring and dissenting statements in Bradshaw. And I'm happy to address the bonus issue if that's where you wish me to go next.
Up to you. Okay,
all right. I was going to move to the House issue next, if that's all right, but I'm happy to go wherever you would like. Okay. The House issue is the issue that we have brought on appeal, and I believe that it is somewhat of a confusing issue. I think it can be confusing even for the most specialized of family law attorneys or, frankly, real estate attorneys. And frankly, we believe that the Court of Appeals got lost in the weeds on this question. The House issue is a question of flowing through differing presumptions and how those presumptions happen when you apply the facts into them. The first presumption is the inception of title presumption. And there is no dispute based on the facts of this case that the house in question was bought by my client before the marriage. The deeds were offered into evidence. There was plenty of evidence, and even the Court of Appeals opinion did not dispute the fact that the house was purchased prior to the marriage. So we start out where we start out with the presumption of community property. Immediately that presumption was rebutted, and then we have a presumption of separate property. Then during the marriage.
Does the record indicate that the reason did they refinance this to lower the interest rate?
Right. During the marriage, they refinanced the deed. I don't think it indicates why they refinanced the mortgage.
But the interest rate went down.
They did refinance it at the times when the interest rates would go down. I don't think the record indicates why they refinanced it. There was a prior refinance before the marriage and then a new refinance during the marriage. Certainly given circumstances in the economy, that would make sense, but I don't think there's a specific recitation as to why. other than,
Well, I think it would be in evidence if it was higher before and lower after.
right, sure, of course, of course. I think there is some statement that there was some cash pulled out as well. But it was definitely in evidence that it was to refinance the deed, not just to, for example, like some of the cases, to transfer ownership. And based on the Cockerham case, the Raymond case, and some of the other cases in the courts of appeals, that is a very important distinction, that the purpose of the refinance, or the purpose of the changing of the deed, was for the purpose of refinance, like in the Cockerham case, to secure the loan. And in this particular situation, the deed that resulted from the refinance during the marriage ended up with a interlineation typed into the deed, which is very curious to me, having bought many properties. I've never seen such a thing, but there's an interlineation that includes wife's name as a co-grantor as well as a co-grantee. And then there's some evidence in the record, admittedly not as direct as maybe we would have all preferred, but there is evidence in the record where her husband testified that she never was a grantor in the first place. He owned it before the marriage, he owned it during the marriage, and he didn't really understand why she was listed as a co-grantor. And so we believe that at that point, there was evidence of a mistake in the deed. And whether counsel argues that there was, whether there was direct, as the Court of Appeals I think hung up on, direct evidence of an intent to gift, I think that is a red herring in this. I would love for there to have been direct evidence of that, but unfortunately, that's not the situation before us. What is before us is that there is clear, undisputed evidence of a mistake in the deed. And at the point that there is...
Even if she shouldn't have been listed as a grantor, why don't we give effect to her being listed as a grantee?
We believe that at the point that there is evidence of a mistake in the deed, that the gift presumption, as the Thayer presumption says, the bubble bursts of the presumption, and the presumption of gift disappears. And then it is left to basically a regular old preponderance of the evidence, a regular old evidentiary question.
Why would there even be any need for a new deed as opposed to a deed of trust if a change in ownership was not,
A lot of times title companies just take charge of those things and do it. I mean, unfortunately, and I think that was reflected in my client's testimony at trial, that the title company did that wife took charge of the transaction, and the title company, told them what documents to sign. And he said, I don't know why the title company did that. And so in my opinion, what happens is that it was then, the burden then shifted back once the bubble burst on the presumption of gift to wife to prove it. And contrary to what the Court of Appeals says, then what happens is that you just look at the evidence. And the Court of Appeals hung up on the fact of whether...
As a general matter, if you sort of go behind the curtain of everybody just signing what the title companies put in front of them, which all of us who've done residential real estate transactions
Exactly.
know that's just kind of what everybody goes and does. And if we go behind that curtain as a court system, every time somebody says, well, I didn't really mean it, that throws a lot of documents into litigation that under a contrary rule could be relied upon on their face.
Well, I think that where we land on that is that the presumption of gift is rebutted, and then it's up to the evidence at trial. And the Court of Appeals seemed to want there to be only direct evidence, but we know that there is an allowance for circumstantial evidence. And so where I come to, and what I believe that the correct answer to this is, that the circumstantial evidence was sufficient, at least more than a scintilla. The Court of Appeals believed that there was legally insufficient evidence, and I disagree with that. I think that there was more than a scintilla of evidence once that presumption bubble was burst. There was more than a scintilla of evidence, of circumstantial evidence, to at least create a fact question, if not to create enough evidence to presumptively support the trial court's decision. So either I believe that there was enough circumstantial evidence to support the trial court's decision, which then it should be affirmed, or there's enough evidence that then there is this factual sufficiency question, which goes back to my standard of review question, which then would, at worst case scenario for my client, require reversal and remand to the trial court for a new trial on characterization, on the question of whether there's enough evidence, circumstantial or otherwise, on the question of characterization of the house. So I believe that there is enough circumstantial evidence to affirm the decision. I believe I'm out of time. I do still want to address the bonus issue, but I can address that, I believe, in rebuttal once they have had their opportunity, unless the court requests me to do otherwise.
Any other questions? Thank you, Ms. O'Neill.
Thank you.
We'll hear from the respondent.
May it please the court, Ms. Bender will present argument for the respondent.
May it please the court. Justice Lehrman, to answer your question about the evidence of the refi, there was no evidence in the record of any kind of interest rates. The only evidence about the refinance that you find in this record is there was testimony by my client, Ms. Lauren Oxusler, about why the parties wanted to refinance. She testified that they were having discussions about she didn't feel like this was her home. She wanted to sell it, buy something that they could buy together. There is absolutely no evidence other than that. There are some statements by Mr. Oxusler that he thought it was strange that the title company would put her name joining in the deed. It does not say that she was a grantor. It does say that he is the grantor joined by his wife. But if we're talking about circumstantial evidence, and I know there's a lot of briefing by Ms. O'Neill about inferences drawn by any kind of circumstantial evidence, I think that the equal inference rule informs us that we've got to look at all the testimony, and the uncontroverted testimony of why that refinance occurred of my client, I think, would have to be considered.
Was the wife obligated on the new note?
She was. She was. And Justice Blaylock, to answer your question, Mr. Oxusler never testified or never said anything about not meaning it on the deed. He said he thought it was strange. He said he thought that they might have made a mistake at the title company, but that was the concern of the Court of Appeals, there was never any testimony or any other evidence, direct or circumstantial, that supported any kind of lack of intent. Ms. O'Neill, I know, argues that that a simple mistake in the deed.
My question is more, I mean, even as judges and lawyers, we might very well sit down at a title company's table and sign things we haven't read very carefully. And the question is just to what extent are we going to go behind that curtain at all and talk about whether you really intended to do the thing that the document you signed reflects?
Well, and I think that's important. I don't think you do, because I think it opens up a hornet's nest for all of us to have to address. If you can sign a document and then change your mind later and say, oh, I didn't intend it that way, that was just somebody else wrote it. There's no testimony in this record that he didn't read it, he didn't understand it, that he didn't sign it, that he didn't know what it said, and most importantly, in this case, there's absolutely no evidence that he didn't intend this as a gift.
But there's no dispute either that she couldn't have been a grantor, right?
There is no dispute that she could not have been a grantor. Our position is that she joined and in the deed, if you look at it, it has his name as the grantor, and then the title company typed just right above that line, joined by his wife, Lauren Oxusler. So it's our position that she was not a grantor, but even if the court did say she was a grantor, I don't believe that mistake in a deed would alter any kind of presumption or be a mistake that would change the presumption that he gifted that to her as her separate property. Certainly if there was a mistake in the deed that listed her as a grantee, I could see that. But a mistake in the deed, it's my position that a mistake in the deed, even if there is one, which was never pled or argued at the trial court level, but if there was a mistake in the deed, it certainly didn't change any presumptions related to his intent.
Well, insufficiency of evidence doesn't usually have to be raised at the trial court level, so I'm not sure if that makes a difference. But are there cases that apply this presumption of separate property by gift where the deed is from both spouses to both spouses? Because Magnus at least articulates it as a deed for transferring property from one spouse as grantor to the other spouse as grantee creates a presumption. So that's not exactly what we have here, but are there cases that apply it to this scenario?
I do not know the answer to that, but I'm happy to brief that issue and answer that question for you post-submission.
What about the Cockerham case and the cases that seem to indicate that parole evidence is admissible when the issue is whether or not one spouse gifted property to another? And I think the other side's argument is, look, parole evidence is admissible under Cockerham and other cases. Here we had some parole evidence, and the trial judge believed the parole evidence, and so we ought to defer to the trial court's ruling on this because there is some evidence to support it. What's your response to that?
So, Justice Bland, I believe that the whole parole evidence argument was not preserved in this case and is not applicable in this case because there absolutely was not legally sufficient evidence. There was no parole evidence. There was no parole evidence offered at trial. There was no parole evidence in the briefing that was submitted to argue, hey, this should have been admitted. There was no offer of proof because there was no evidence.
So you're saying, oh, I'll take them, I'll spot them that, but the only evidence that was admitted was that this looked strange, and that isn't enough to create to support the trial court's ruling for this house dispute. Correct.
And that's our position, is that you don't even have to get into the question of parole evidence, which is what the Court of Appeals said. They noted that we had made that argument, but they didn't even reach that argument because the evidence was not legally sufficient to rebut any presumption of a gift of her separate property. So the Court of Appeals found the evidence was legally insufficient to rebut the presumption and rendered judgment on the house that each spouse owned one half as his or her separate property. I'd like to, unless there are other questions about, I do want to clarify too. There's been in the briefing and then represented today, that there was evidence that wife took charge of the transaction, that neither party were attorneys. Wife had a duty to inform husband of the change in ownership, but none of that appears in the record anywhere. And in the briefing, there's no cites to the record, so that's just not part of this record that's to be considered or was considered by the trial court or the Court of Appeals. I'd like to move on and address the bonus issue, since that is my issue on appeal. And in this case, Lauren Oxusler, who was the wife, asked this court to articulate a bright line rule on bonuses that upholds a community interest for compensation for work that was performed during the marriage, and do that on a pro rata basis like we do other forms of deferred compensation, so that it doesn't create prejudice or windfall to either the community property or the separate property.
The record here reflects that this bonus was based on his work during the calendar year of 2019. That's correct?
That's correct.
What if the record showed that the bonus was based on his work from January 1 of 19 through the date the bonus was paid? How would the current law treat that amount for purposes of community property determinations?
So that's where we don't have any bright line rules on how that's treated, either by the legislature or by this court. family code requires a trial court to determine the rights of both parties in deferred compensation, including a bonus. And the key phrase in that 7.003 is in the nature of compensation. And what we're proposing is that this court make it clear that just like other forms of deferred compensation, it's a time allocation method used to determine the months that the work was performed during marriage versus a fraction that would be paid for as separate property.
Isn't
So
it
it could be
true?
mixed character property.
But I don't know that we would even need to go there as far as mixed character. If you look at inception of title and as to when each individual dollar was earned. And so if we look at, you know, that any type of bonus that was earned during the marriage is community property. And I believe in this case, the board had actually decided to grant the bonus during the marriage, then that would take care of it without having to change the law with regard to inception of title, right?
So just for clarity's sake, Justice Lehrman, the managers recommended the bonus in November of 2019.
Right.
The board did not approve that decision until January of 2020.
But I understand that, that's what I meant.
Yes, but
that
it
the
was
board had-
recommended, the amount was recommended to the board, and so the amount at least was determined, and the.
It was discretionary in the sense that the board, that it could be decided later on that he would not get it, but the decision had been made before that.
Yes,
Could-
and
but the company could have said, no bonus, zero. Right, so
exactly,
it's totally discretionary, and,
Sure.
and I wonder how that can be characterized as having been earned. I mean, if he'd done something after, you know, in the intervening time, like between he supposedly did the work that earned this, and then the time they were deciding whether to give it to him, what if he, you know, runs his car through the front of the building or something, and they don't want to give him a bonus anymore? I mean, he hasn't earned it until they make the decision to give it to him. Seems to me to be the natural way to look at this kind of a thing.
I think you have to look at when the compensation, when the work was performed, giving rise to the compensation.
But even under that approach, and I don't want to stop you from answering Justice Blacklock's question, but let me throw this in as well. He had to still be working there to get the bonus. So it wasn't it at least partially earned the day it was paid? Because if he had left, he wasn't going to get a bonus.
Sure, and I think that's where we get into the contingency interest.
Right.
And, you know,
That's why I asked the question initially about what if it was based on that whole period? Because in a sense it was, because he had to still be there.
He had to still be there, but in the record, in this case, it's undisputed, the compensation executive testified that the bonus was being awarded for work performed during 2019. And although he had to still be there, that was a contingency that certainly he could have been divested of that. But once the contingency, once the discretion was exercised and he was paid this bonus, I think the most equitable way, both for the community and the separate, is to look at it from a frame of when was the work performed, giving rise to the compensation. Otherwise, you end up with a situation, the rule that they're advocating is a situation where an employee could get paid $10 in salary for the year, but his compensation structure gives him $1 million bonus at the end of each year. If they get divorced on December 31st and he gets paid that $1 million on January 1, that's the situation where the rule that they're espousing, where it's not earned until it's paid, that's just inequitable to the community.
What
It
about an
creates-
advance? What if there's an advance on a book and they say, I'm going to pay you now $1 million, you're going to write the book, and 2 years later we're going to publish it? Have I not earned that, you know, until I write the book? Or hadn't that come in the door and then that's community property?
I think that that's similar to the Loaiza case where we had the baseball player and he had a signing bonus, but the court decided that the court decided in that case that because it still required skilled performance after the date of divorce, that it wasn't all earned during the marriage. Or it wasn't compensation for work done all during the marriage, because it still required him to perform skilled services as a baseball player.
So you would say that the advance is not community property if it's in contemplation of, future labor, even if they have no right to get it back from me?
I think that's why it's important for us to look at, and even the Loaiza case does this. It said that this was a claim for compensation for when the work is performed. And I think.
And how does Searly play into all this? Isn't that what we held in Searly with regard to vesting and the irrelevance of that?
Yes, I mean, I think Searly is directly on point. I think petitioner would like this court to go back to an old vesting requirement, only they're rephrasing it in the form of a contractual enforceability. Okay, if I don't have the right to go to my employer and I run into the front of the building and you decide not to pay me, everybody shares the risk. If this is awarded as a contingent asset, everybody shares the risk that it may never materialize. But in Searly, this court said, you know what, that old vesting requirement, that's gone. We recognize that contingent assets should be awarded in a divorce, and that then if the contingency, if as and when, for example, if as and when this bonus is paid, it's compensation for work that was performed during marriage, and to the extent it was, that compensates the community.
Does the employer's extent of discretion or history of payment, non-payment come into play?
Sure. There was an employment letter that Mr. Oxusler received when he started employment in 2008 that stated that every year the bonus would be paid. It was at the discretion of Bank of America. You know, if they had a bad year, they don't have to pay. But every year on February 15th, if you earned a bonus, you got paid on February 15th for performance based on the prior year's work. There was testimony that had been paid every year.
If there were more discretion with the employer to pay or not pay, would that matter?
I don't think it does. I think once the discretion is exercised and the amount is actually paid, I think the factual analysis is it compensation for work that was performed during the marriage? And if it is, I think that's where we have long-standing.
What if the employer testifies that I don't consider this compensation for past work, I consider this motivation for future work?
Then I
don't owe him a dime, I want him to work even harder next year in hopes that he'll get this bonus again. I mean.
Then I think that that's a fact issue, and I think that would be different. I mean, I think that it's different if you have.
But isn't that for most, I mean, if I was an employer, I think that would be my motivation for providing discretionary bonuses. It wouldn't, because I've already got the work from you for the year that's passed. I don't need to pay you more for that. What I want you to do is stay here and work harder, and so that's why I'm giving you a bonus. So just the whole idea that the money's been earned when you're getting a discretionary bonus at the end of the year that they could just as easily not give you. That word earned suggests reciprocal obligations, and I understand you say there's case law otherwise. I'm really struggling conceptually with why we wouldn't just look at the day the money comes in the door, whether it's an advance or a bonus after the fact or whatever it is. It's so much easier to administer that rule, and it
Well,
seems
I
to make
think
sense.
that rule, actually, Justice Blaylock, I think that rule, Blacklock, that rule is subject to, it creates a lot of room for manipulation and gamesmanship. It would result in just an unequitable forfeiture to the community. I mean, if we're saying the fast and hard rule, the line drawn is the date it's paid, we're setting it up for spouses to go to their employers and say, don't pay my compensation until after my divorce, and then then I get a windfall, and the community is deprived of the benefit of its work.
Suppose everything happened in this case the way that it did, except for the manager's recommendation of the bonus came after the divorce. Would that change anything or not?
I don't think it does. I think you still go back to this was the testimony that this was compensation for work that he performed during 2019 of which they were married until December 16th, roughly, of that year. So roughly 99% of it was earned while he was married, and therefore I believe that that amount, if as and when paid, which we know it was paid, that became, that belonged to the community.
Is there any temporal limitation? Say, for example, you have an amount paid for 10 years of service, but the couple were married only for the first of those 10 years. Then what, under your theory?
Well, that's where I think it's the pro rata distribution, just like we do with the retirement accounts, the pension funds. We base it fractionally on the
claim
time
would be
married
that-
versus the time.
That she's entitled to 5%, is that right? Just in terms of the actual numbers?
In our case?
No, in this hypothetical.
Oh, in this
that I'm posing.
hypothetical, possibly. So I don't know what percentage that would
Well,
be,
10,
but
you know,
for
1
the months
year-
of marriage.
1 year out of 10 years is 10%, and then you would claim 50% of that.
Yes.
Is that right?
So it would be divided fractionally upon the number of months. There's a formula in the family code for the retirement accounts that the Taggart formula does
So you-
that for us.
The theory you're advancing is just to borrow that formula and layer it on to bonuses or other kinds of deferred compensation.
Yes, Your Honor. So the legislature and/or this court has addressed all of the, what I can tell, all of the other deferred benefits, something that's earned, such as retirement, annuity, stock options, has addressed all of those absent a bonus, either through the legislative process or the statutes or through the case law from this court. So we're just asking the court to follow what the legislature has approved of already as a method of allocation, to characterize that between the proper marital estates based on when the work was performed.
Any other questions? Thank you, Ms. Bender.
Thank you.
Ms. O'Neill, you have 5 minutes.
Thank you, Your Honor. May it please the court. 2 points on the House issue before moving to the bonus. One, Justice Blacklock, you asked me a question about going behind the curtain. And my answer to your question would be that I don't think we go behind the curtain on every single time that everybody signs real estate documents. I think we only go behind the curtain when there's a mistake in the deed. Or fraud or duress. And I think that's what the law clearly is. And in this case, this deed, I just disagree with the representations of counsel. I think when you look at the deed, which is P26 in the record, it clearly says that the undersigned, Hakan Aksuzler, and then the interlineation says, joined herein by his wife, Lauren M. Aksuzler, acting herein by and through its duly authorized agent, hereinafter called grantor. And so I disagree with her that her client is not included as grantor. I think that the language does actually include her as grantor. And so I do think that the fact that she is included as a grantor creates that mistake in the deed, which then rebuts the presumption. So I wanted to clarify my answer to your question. Moving to the bonus issue. To me, I believe that the very important distinction between the matters that the legislature has addressed, which include all of these types of deferred compensation, versus a bonus, is very important. The legislature has not addressed a bonus. If the legislature wanted to address a bonus, the legislature would have addressed a bonus, and they have not. So it's left to this court to attempt to interpret what a bonus is. And to me, I promise I'm not going to sing to you today, but we always start at the very beginning. And to me, the very beginning is Family Code 3.002. Family Code 3.002 defines that it says that community property, which are, we know, the assets that a court can divide during a divorce, are the assets acquired by a spouse during the marriage. And acquired is defined by looking to the origin or inception of title. Now, counsel tries to say that I'm being somehow curmudgeonly, or I forget the exact word she used, and I admit I've been practicing law a really long time, but I don't think that inception of title is curmudgeonly or
Origin,
old.
origin, you said.
Origin or inception of
The
title.
origin of it would be the work that was done during the marriage.
Well, I think that when you look at the word acquired and inception of title, inception means that when the party had the first right to claim the property or when the title vested. And when we look at deferred compensation, and I believe Justice Lehrman asked that about deferred compensation, a bonus is not deferred compensation. A bonus is a contractual right, in this case at least, determined by the employment contract. Now, some cases, as Justice Blacklock says, are just loosey-goosey types of bonuses that you get at Christmas with a pat on the head, and hopefully they're done to encourage future performance. But in this case, it is a matter of contract. It is a matter of plan documents. It's a matter of these very thick documents that Bank of America has that define what the bonus is. And when you look at the difference between the Searley case, the retirement benefits actually deferred compensation, or other types, unvested stock options, where we have statutory definitions of what happens to those types of deferred compensation. Deferred compensation are types of compensation that are earned at a particular time, but passed off until later, like retirement, so we have it to spend later. But bonuses are not that. And in this case, the contract actually defined how the bonus was going to be determined. The documents, 6 Reporters Record A30 says it's an annual incentive provided by the company based on overall performance. It does not say based on annual performance. It says based on overall performance of the employee. The gentleman that testified said it is not based on the actual commissions, not based on the work of that year. It's based on overall performance and success of the company. He said it is discretionary. It is awarded in January after the divorce, and it requires that the guy be employed on the day it is awarded. It is a purely discretionary bonus, and it is an expectancy until received. That is what the gentleman testified to. And to think that my client could have somehow had a right to that bonus, to have sued his employer for that bonus somehow before the day he received it, in other words, acquired or had vested title to that bonus prior to the day he received it, I mean, he just couldn't have. So how in the world could it have been awarded as a community asset?
Any other questions? Thank you, Ms. O'Neill.
Thank you.
The case is submitted. That concludes the arguments in the cases set for this morning. And the marshal will adjourn.
All rise. Oyez, oyez, oyez. The Honorable Supreme Court of Texas now stands adjourned.